Hi, I'm Mark Lazarus with Russell & Lazarus, personal injury attorneys here in California. We help clients who've been injured in accidents to get great medical treatment, get their medical bills paid, and get compensated for the injuries that they've suffered. Today, we're going to talk about what an adjuster says versus what an adjuster means. Many clients want to know more about how they should interact with insurance adjusters, so that's what I'm going to discuss with you today. An insurance claims adjuster will employ a variety of negotiating tactics to get you to settle your claim for as little as possible. Let's look at 4 statements that claims adjusters might make in conversations with you to learn what the adjuster really means and how you should respond. First, when the adjuster says, "I'd like to take your statement," what she really means is, "I want you to commit to one version of what happened right now so I can use it against you if you try to change your story later." Adjusters are paid to investigate claims and gather facts. The linchpin of their investigation is your statement. And believe me, when I tell you, the adjuster will try to get you on the phone or in person as soon as possible after the accident. Why? Symptoms often get worse in the 24 to 48 hours after an accident. They want to catch you while you're still in shock and before the symptoms really set in. The adjuster will use your statement to A, commit to a version of what happened, B, question your credibility if you correct an innocent mistake or add or overlook a detail, C, for interpretations that reduce your claim's value, and D, disprove injuries that you suffered which worsen after the statement is given. Next, when the adjuster says, "Please sign this medical authorization form," what she really means is, "Please sign this form so I can gain access to your entire medical history going back to the womb and perhaps find something I can use against you." Adjusters frequently ask claimants to sign a medical authorization. This gives the adjuster permission to obtain copies of your medical records. The problem is that most of these insurance company authorizations are broadly drafted and give adjusters the ability to go into a claimant's complete medical and psychological history, as opposed to just obtaining records related to the treatment for the accident itself. This allows the insurance company to pry into pre-existing conditions and medical or psychological issues. Most claimants who do not have a lawyer will sign these medical releases because they think if they cooperate with the adjuster, this will increase the chances of getting a prompt and fair settlement. Usually, signing will come back to bite them later. Next, when an adjuster says, "Why do you need an attorney? I'll work with you on the claim," what she really means is, "Please don't call an attorney. When an attorney gets involved, it becomes much harder for me to push you into a fast and cheap settlement." When the adjuster deals with an unrepresented claimant, the adjuster has the upper hand because she knows how the system works and she's been trained in negotiation. Once a personal injury attorney gets involved, the adjuster loses her advantage. As a result, to discourage you from contacting an attorney, the adjuster might say, "Your claim won't be any more valuable just because you got an attorney." This is false. The price tag of a claim almost always goes up when an attorney gets involved. Or the adjuster will say, "Why do you need an attorney if I'm looking out for your best interests?" Not true. The adjuster is actually seeking the opposite. He or she wants to pay you as little as you will accept. Or adjuster will say, "If you get a lawyer, we will have to hire one as well to take your deposition." True, but if the case proceeds that far, a deposition is nothing to fear. You merely are giving your statement in person with your attorney at your side. Adjuster might also say, "If you hire a lawyer, it will slow down the claims process." True, but is also likely to result in a much better outcome. Lastly, adjusters will say, "If you don't accept this amount now, we will withdraw all offers." What she really means is, "Please take this low offer so I can close your file and get it off my desk." This is often a bluff. If your case is worth $20,000 today, it will likely still be worth $20,000 tomorrow and the next week and the next month. If it is not a bluff and the claims adjuster withdraws the offer, consider the withdrawal an invitation to file a lawsuit. To recap, don't give a statement. Require limiting language on any medical authorization form you sign. Understand that the adjuster really does not want you to retain an attorney. Do not fear the adjuster's threats to withdraw all offers. Compare the adjuster's last offer to your claim's value and then decide whether to accept it. If you need help evaluating your claim's value, call us to discuss it. There's never a charge to consult with us. Whether you hire us or not, you can contact us at 800-268-9228. Thank you so much.